Hello, my name is Dr. Siobhan Bhriain. I'm the National Lead for Integrated Care in the HSE, and I've been leading on consent for vaccination against COVID-19 since the vaccination programme started in January 2021. Today, I'm going to talk a little bit about consent for vaccination against COVID-19 for 12 to 15-year-olds. So as we know, vaccination against COVID-19 of young people in the 12 to 15-year-old age bracket has been approved since July of 2021 in Ireland. Most of these young people will be vaccinated at a mass vaccination centre. However, some may attend their GP or local pharmacy. And the purpose of the talk today is to give you an understanding of the consent process for this age group. So what is consent? Consent is the giving of permission or agreement for an intervention, receipt, or use of a service or participation in research following a process of communication about the proposed intervention. Assent, on the other hand, is the agreement, approval, and/or permission to an intervention, receipt, or use of a service or participation in research following a process of communication. But it doesn't necessarily mean that somebody has the capacity to assent. It does mean that they will agree to having the procedure or intervention, and in this case, vaccination. You can find out a little bit more about this on the HSE National Consent Policy. So specifically to vaccinate 12 to 15-year-olds, it's a legal requirement that a parent or legal guardian must consent in advance of the vaccination of a young person between 12 and 15. It's best practice for vaccinators to check consent at the time of vaccination. So you need to know, if the parent or legal guardian is not with the 12 to 15-year-old, that the person who gave consent online is in fact their parent or legal guardian. If they are not, then they should not be vaccinated until parental or legal guardian consent has been obtained. And this could have happened if, for example, a child's aunt or uncle, older sibling, or somebody other than their parent or legal guardian actually did the consent online for them. You just need the consent of one parent or legal guardian for vaccination to go ahead. However, the young person should also assent to receiving the vaccine and may require additional support to do this. So this could mean that they may have some questions they want to ask themselves of you, the vaccinator, or just you assuring that they've had the opportunity to ask any questions they want to ask. It's very important that if a 12 or to 15-year-old does not assent and refuses vaccination, that they should not be restrained to be vaccinated or vaccinated against their will. So what constitutes a legal guardian? Well, if the child's mother and father are married, both are the legal guardians. In the case of a separation or divorce, both parents remain the child's legal guardian, even if the child is not living with them and they have not been awarded custody of the child. So where a child has been jointly adopted, the adoptive parents are the child's legal guardians. In the case of a same-sex couple who are married, the child's biological parent is the legal guardian. However, the partner or spouse may apply to become a legal guardian also. Where the child's parents aren't married, the child's mother is automatically the legal guardian, and the child's father is automatically the legal guardian if, from January 2016, he has lived with the child's mother for 12 consecutive months, including at least 3 months with the mother and child following the child's birth. He may also be the legal guardian if the mother and father of the child make a statutory declaration to the effect that they agree to the appointment of the father as a legal guardian. And the father may apply to the court to be appointed as a legal guardian. Any adult can apply to the courts for legal guardianship if they are married to or in a civil partnership with or have been cohabitating for at least 3 years with the child's parent and have shared parental responsibility for the child's day-to-day care for at least 2 years. Or if they have provided for the child's day-to-day care for the continuous period of more than 12 months and the child has no parent or guardian who is willing or able to act as that guardian. A guardian may also nominate another person to act as temporary guardian in the event of the guardian's incapacity. However, this is subject to court approval. And a guardian may appoint a person to act as the child's guardian in the event of the guardian's death. Now, specifically when it comes to children in care, there are particular things to consider. So if a child or young person is in voluntary care, the usual rules of parental consent apply. In other words, you need the consent of one parent or legal guardian. For children or young people who are under a care order, if a young person over 16 years of age is admitted to the care of TUSLA, i.e. on the order of a court, the normal rules apply. In other words, the 16 or 17-year-old can consent for themselves. If a child or a young person under 16 is admitted to the care of TUSLA under a care order, the normal rules do not apply. However, it is best practice to involve the parents in decision making where possible. So specifically, a child who's under a care order may be under an interim or emergency care order. In this case, an application may be made to the district court in regard to consent for the treatment or intervention, including that a social care professional involved with the child's care is permitted to give consent to the treatment or intervention, in this case, vaccination against COVID-19. For children who are under either permanent or temporary full care orders, TUSLA is authorised by the court to consent to any necessary medical or psychiatric treatment, assessment or examination. It's important to be aware here that different procedures apply to the admission and treatment under the Mental Health Act. And it's equally important to be aware that if there is a request for vaccination, that the child assents to the procedure and is not forcibly vaccinated. So for children in foster care, the consent of TUSLA is required for any treatment or intervention. TUSLA should affirm that they have the legal authority to give consent on behalf of the child. If a child or young person is in foster care for 5 years or more, the foster care may apply to the district court for an order, giving them control over the child, including giving consent to any necessary treatment. A healthcare worker should satisfy themselves that the foster carer has the necessary legal authority to consent to the treatment and intervention in question, in other words, checking the court order. And again, in the case of all these children, it's important that they too assent to the treatment and are not forcibly vaccinated. So, what does it mean for a parent or legal guardian to give informed consent? Well, the parent needs to have adequate and clearly presented information about the nature, potential risks and benefits, and of the alternatives to not being vaccinated. They need to be not under duress when making the decision, and they need to have capacity to make the decision. If there are concerns that a parent or guardian does not understand the information provided or is seeking further information, they should be given the time and opportunity to do so. However, it's important to note that there is a presumption in law that adults have the capacity to consent unless there are reasons to believe otherwise. So for the recording of consent for this group, most young people will be registered online using the HSE registration system. A paper version can be completed and maintained as a record in other settings where young people are vaccinated. So, for example, if you're a GP or a pharmacist, you may wish to keep this as part of your record. Vaccinators will have an opportunity to review the recording of consent and confirm this as part of the vaccination administration process. Although we're talking about 12 to 15-year-olds today, I'm just going to say briefly that there is a difference between consent for vaccination for 16 to 17-year-olds and that it does differ from 12 to 15-year-olds. The main difference is that young people of 16 to 17 years of age can consent for themselves. While it's important that they have parental support, it does not determine if a vaccination happens or not. So if a 16 or 17-year-old is requesting vaccination, they want to be vaccinated, they are entitled to that vaccination, irrespective of what their parent or legal guardian says. If that young person consents and the parent refuses, the vaccination should proceed. We have further guidance developed for consent to vaccination of young people aged 16 to 17-year-old on the following website. And we have more information there for anybody who may wish to find out more about this. I hope this was helpful. Thank you very much.